Legislature's back in order. We have one bill and 3 resolutions still on the second reading. Let's start with the one bill. Madam Vice Speaker, you recognized. And 203.
Good morning, Speaker and colleagues, and thank you. I move to place Bill number 203-34 on the third reading as substituted by the Committee on Culture and Justice. And I would like to speak on the bill.
Any objection? Everybody has a copy? No objections?
Thank you, Mr. Speaker. Bill 203, as substituted, would allow for the establishment of a DWI, driving while impaired, treatment court program to support the judiciary's efforts to reduce recidivism for medium and high-risk offenders and to address their risks and needs through the implementation of therapeutic treatment for addiction and rehabilitation. It would give more judicial discretion to take away driving privileges and impose fines and incarceration. The legislation was drafted in close consultation with the Judiciary of Guam's DWI Treatment Court Executive Committee, the Office of the Attorney General, the Guam Public Defender Service Corporation, Alternative Public Defender, the Office of Highway Safety at the Department of Public Works, the Guam Police Department and its Guam Highway Patrol, the compiler of laws, the Department of Revenue and Taxation, and the Department of Corrections. The bill maintains current regulations which make it unlawful to drive with a blood alcohol content of 0.08% for adults over the age of 21 years old and 0.04% for adults under the age of 21 years old. It also maintains that it is unlawful to drive under the influence of a controlled substance. The offense levels and fines imposed for each conviction of offense resulting in bodily harm remain the same as current statute. However, the new Safe Streets Act would allow the DWI Treatment Court to remove or reduce any restriction on a person's privilege to drive or to reduce any fine imposed upon the person's successful participation in the DWI Treatment Court and completion of any terms or conditions imposed. This allows the DWI Treatment Court to provide incentives and interventions to encourage successful outcomes and reduce recidivism. During the public hearing, both the presiding judge and the Attorney General testified that a large majority of first-time offenders of driving while impaired would not reoffend again. If those convicted on first-time offenses of DWI successfully complete the DWI Treatment Court program, the judge may order the case dismissed and expunged. No conditional discharge or dismissals will be permitted for offenses involving serious injuries. The DWI Treatment Court would be able to focus more on repeat offenders in need of the therapeutic treatment and interventions. The substituted version also transfers, this substituted version repeals the Safe Streets Act of 1993, sections 18101 through 18124 and section 18125, and Article 3, all from Chapter 18, Title 16, the Vehicle Code of the Guam Code Annotated, as recommended in the testimony from the Attorney General. These sections are rewritten in a new Article 1 of Chapter 92 of Title 9, which is the Crimes and Corrections Code in the Guam Code Annotated, and would be titled the Safe Streets Act of 2018. The substituted version also transfers Section 18124.1 in Chapter 18, Title 16, to the Rules of the Road section in the same title, but a different chapter, Chapter 3. That's also been recommended by the Attorney General. Additionally, the substituted version moves the implied consent law in Article 2 of Chapter 18 in Title 16 to Title 9, the Criminal Code, with no amendments. And it is important that there are no amendments made to this section because this section is under challenge. This implied consent law is currently under challenge, and we are merely moving it to the Criminal Code instead of the Vehicle Code at the recommendation of this task force. It's also, this bill would also move the ignition interlock devices in Article 4 of Chapter 18 in Title 16, the Vehicle Code, to the Criminal Code with no amendments, as recommended in the written testimony from the Attorney General. Based on testimony from the Judiciary, the Office of the Attorney General, the Public Defender, and the Guam Police Department, the following changes were also incorporated into the substituted version. We added language in Section 2 that authorizes the Judicial Council of the Judiciary of Guam to establish DW treatment court through a duly adopted resolution in order to be consistent with current language in the statutes relative to establishing specialty courts. We added the definition for negligence and amended the definition of prior offenses as recommended in written testimony from Attorney General. We removed Section 5 of the previous subsection E from 92102, which read, quote, E, having any level of a controlled substance in his or her blood or urine, unquote. The Guam Police Department, in their written testimony, raised the concern that this language would make enforcement difficult and may criminalize individuals who are not impaired while driving but are taking prescription medication. The mandatory minimum fine amounts in 92104, 92105, 92106, and 92107 were kept the same as the current statute instead of decreasing these fines as proposed in the introduced bill. The offense levels for drinking while driving a motor vehicle, driving while riding in a motor vehicle, drinking while riding in a motor vehicle, and open container of alcohol were kept the same as the current statute rather than reduced, as recommended again by the testimony of the Guam Police Department. I ask my colleagues to please support this bill and the judiciary and all of its stakeholders, as evidenced by the hard work that they also put into this bill, to support the repeated driving while impaired offenses, and to ensure that those people get the treatment that they need to truly end this issue on Guam. Thank you.
Thank you very much, Senator Argan. You're recognized. Then Senator Torres.
Buenas and afternoon, Mr. Speaker, and all the senators in the hall. Mr. Speaker, I certainly want to stand in full support of the proposed legislation, which is to establish the DWI treatment court. And you, having served directly within the judiciary of Guam, certainly have seen the benefits of some of our treatment courts that exist today. Specifically, the drug treatment courts, which are inclusive of the adult drug treatment courts as well as the juvenile drug treatment courts. I know initially when these programs were stood up that they were able to acquire some federal funds, and then they transitioned to a local funding component. And even during the course of the transition to local funds, which we were successful in ensuring and securing those resources back in 2003, 2004, as they transitioned from federal funds to local funds. One thing that really stood out, Mr. Speaker, is that the programs, whether it be the adult treatment court or the juvenile treatment court, the recidivism rate, this is the rate that reflects the number of participants and whether in fact they fall back into the same situation prior to entering to the treatment court. The local recidivism rate at that time that was shared with us, which was the greatest justification for the local community owning up to funding the drug treatment courts, was that the recidivism rates were at that time about 17%. Nationwide, it ranged anywhere from 27 to about 35%. So it shows that at least as it applied to the establishment of the drug courts and that particular treatment that is necessary within the system, it's been a success. So I certainly stand in recognition of that particular program. But also, Mr. Speaker, 2 years ago, I know that you supported the establishment by law of the Veterans Treatment Court. That already has been in operation for a few years. We have seen perhaps 2 or 3 graduation ceremonies that have taken place where, in fact, a number of our veterans who were eligible to participate in the treatment courts have undertaken this entire process, which they continue to say is not only beyond a year time frame, but it's extremely tasking in terms of the requirements that they impose on the participants. And a number of veterans have come out and they have shared personal experiences with me that it certainly has assisted them in terms of transitioning and making sure that they stay on the right path. So, Mr. Speaker, I've seen literally not only the adult drug courts, the juvenile drug courts, and also the veterans treatment courts certainly provide some much necessary treatment services to our people in the community. And in this particular case, it would be codifying the DWI treatment court, establishing that so that in fact the judiciary of Guam can continue to provide the needed services and the wonderful service that they provide our community. So, Mr. Speaker, I stand in support of this particular proposal. Thank you very much.
Thank you very much, Senator. Senator Torres, you're recognized.
Thank you, Mr. Speaker. I just had a few questions to the author, if she will so yield. The first question that I have is on page 1, section 2, with regard to the authority to establish a DWI court. The author mentioned that it is by statute that specialty courts are stood up by the Judicial Council, but I wanted to ask, I'm familiar with the Organic Act provision, 48 U.S.C. section 1424(1) A2, and that section specifically states that the Supreme Court may, by rules of such court, create divisions of the Superior Court of Guam and other local courts of Guam. So my question is, my understanding is it's within the Supreme Court's jurisdiction to stand up the court as opposed to the Judicial Council of the judiciary, and I just wanted that clarification, because by the Organic Act, that's my understanding of how the courts are stood up. It's within the authority of the Supreme Court. So if that can be clarified.
Vice Speaker.
All I know is that the original bill said, well, okay, I would have to check, but all I know is that in the current statutes, there are other treatment courts that have been set up, and those were all set up by consent of the Judicial Council. So I just wanted this one to be consistent. And the court has submitted testimony, and in fact, they were the primary impetus behind this bill, and I don't think they have any objection to its current form. I mean, I asked them specifically, and they reviewed it, and they did not have any objection.
Senator Torres.
All right. Because I have heard otherwise, so I think maybe we'll just have legal counsel, if I may request legal counsel, just reconfirm that authority, if in fact, because I believe there may be a conflict, and so if it's a matter of just making a determination of which or the other is in fact what should go into statute. The other question that I had is the law refers in a few places to persons under the age of 21 operating. For example, on page 36, line 24. Again, on page 47, line 15. And I think on page 46 also. But the question that I have to the author is, given that and these sections refer to the person driving with a blood alcohol level percent that is lower than the 0.08. And my question to the author is, if in fact our laws do not provide for drinking under the age of 21, why would there be a need to have a reference to a blood alcohol level for persons under 21 years of age in our statute when, in fact, that is unlawful? So I'm just a little confused, and I understand that this law was updated and corrected from a previous version, taking it from one statute and putting it in, taking it from the vehicle statute and putting it in the criminal code instead. I understand the practicality of moving it to a place where it's better referenced, but in light of the fact that the law has since changed with regard to the age of drinking, why would we even reference a blood alcohol level separate and apart from what is the legal age? Because that would almost lead one to believe that if you didn't meet this blood alcohol level at 18 years of age, you wouldn't be convicted under the statute, but technically you shouldn't even be driving. It would be an underage issue as opposed to a DWI issue, or both.
Bill, Vice Speaker.
Sure. It's a very good question. I'm not sure if this continues to be necessary, but I think it would, because we definitely want it to be explicit, and that it is a crime to be driving while impaired versus the crime to purchase alcohol under the age limit. I just think those are two separate things, and this is something that is also needed. And whether it should be 0.00 or even a lesser amount, I don't know. But this is the recommendation from the treatment court. So I understand the concern. I just think we do need a separate provision that makes driving while impaired, it's different from receiving alcohol, buying alcohol, or even drinking alcohol.
I think it would make them eligible for the treatment court here as opposed to just a offense of drinking alcohol and walking down the street. Wouldn't have you in this treatment court. You would just be.
And I suppose that is true, come to think of it, because it is illegal to drive under the age of 21, although it's illegal to drink under the age of 21. And if the two should happen concurrently, then yeah, okay, that makes sense then, that there should be a threshold that's separate, different for a person who may be intoxicated at a younger age than 21. Although, the question is but I see how you would have to provide for a different threshold. And then the only other question that I had is, in looking at the different statutes, sections, for example, beginning on 92-108, that has, separate types of offenses, are the minimum standards, are the minimum amounts of sentencing here, minimum and maximum, are they intended to be enhancements to the crime, to the sentences that would happen generally under DWI, under section 92-102, or are they intended to be separate charges? In other words, if you're convicted with a DWI and then you have another type of offense on top of that DWI with bodily injuries, for example, are they enhancements to that, or are they separate charges? Or I'm just trying to understand how that plays out.
That's correct. They are, in addition to the underlying driving while impaired, there is a higher crime, I guess, a more vehicular negligence with bodily injuries. Of course, the penalties are higher, and the term of incarceration are supposed to be higher in those instances. And yes,
Okay.
these are, going to be up to the Attorney General which one to charge under, but yes, there's several of these different charges that could be added to the basic charge of driving while impaired.
And the sentence is to be compounded then?
Correct.
Okay, all right, because
And-
I was just noting while looking at these that, for example, if you were convicted under driving with a child on board, that could be less than the offense, for example, if you were a fourth offender, you know, and if you were to charge one, you could almost pick and choose the lesser of the impacts and charge with that, so.
Yes, just to note that the amounts were actually, they had requested that these amounts, fines be reduced, but the committee voted to keep these amounts intact in the higher levels that they are currently in statute.
Okay. Thank you, Mr. Chairman. I appreciate the indulgence of the sponsor of this bill. It's a very comprehensive bill, and sometimes we just want to be clear about what it is that we're voting on, or being asked to vote on. But I just want to express that I stand in support, and I'm appreciative of the author's efforts to clean up the statute and put it in a more searchable area of the law. Thank you.
On the main motion, Senator Nicholas.
Thank you, Mr. Speaker. I have several items. The first is starting on page 31, lines 23 and 24. This proposed section is a proposed section 92-102, driving while impaired. And it reads, "It is unlawful for a person to drive, operate, or be in physical control of any motor vehicle within the territory, A, while under the influence of alcohol, B, while under the influence of a controlled substance." And then it goes on to C, having an alcohol concentrate of 0.08%, D, having an alcohol concentrate of 0.04% for people under the age of 21, E, having inhaled, ingested, or otherwise any poison, chemical, solvent, or basically any substance that would cause them to be impaired. And F, any influence of any combinations of the subsections. But on lines 23 and 24, Mr. Speaker, I have a concern because it will be unlawful for a person to drive, operate, or be in physical control of any motor vehicle while under the influence of alcohol. Which means if you have one beer, it is unlawful. And I know you're looking at me kind of funny, but if we go back and we look at the definitions, there is no definition for what is under the influence. That was stricken through and changed. So we only have on page 30, line 3, driving while impaired. And if you go back and you reference the original language that was stricken through on page page 3, starting on line 27, it spells out what is under the influence. But if we were to adopt the statute, we would not clearly articulate what is under the influence. And so anything is therefore an influence. You take a Tylenol, you drink one beer, you're under the influence. We need to tighten the definitions, Mr. Speaker, because what defines or what creates a threshold for influence is no longer in the definitions of this proposed statute. So that's one concern on page 31, lines 23 and 24. Another item I have is on page 32, reckless driving while impaired, line 13, section 92-103. That first section A, I'm trying to clearly understand what that section A is saying. It reads, any person who, in reckless disregard for the safety of persons or property, operates a motor vehicle while driving impaired shall be guilty of a petty misdemeanor and shall not be considered a prior conviction under Section 92102. But Section 92102 is the proposed driving while impaired statute. And so the way I read that Section A is, any person who operates a motor vehicle while impaired, it shall not be considered a prior conviction under 92102. But what if they did have a prior conviction? And so after the comma there, in reckless disregard, the way it reads is, so long as you are recklessly disregarding the safety of persons or property, then it's not a prior. So I'm trying to reconcile that subsection A. Another item I have is on page 33. Line 2, a person convicted of a first violation of sentenced as follows. I'm not quite sure, shall be sentenced as follows, or if that needs to be, that definitely needs to be clarified there. And then on line 10, page 33, line 2. And then line 10, suspension of a person's driving privilege for 6 months with occupational driving privileges. Now that's a very open-ended, there's no definition in the definitions terms for what defines occupational driving privileges. In the previous statute, it's very narrow. Your driving privileges are to and from your place of work, and that's it. Occupational driving privileges, unless we define it, somebody can say that they're driving all over the place marketing their business. Or they're driving all over the place, you know, picking up something for work. There are other items that I wanted to bring up. Another one was, you know, throughout the entire offender conviction sections, after the first, for example, on page 33, starting on line 26, all the way to line 8 on the corresponding page 34, and then also on page 34, starting on line 26 into page 35, ending on line 8. Basically, there's a cut and paste of the reduction of sentence if they finish the DWI court. But I'm of the mind that if you were a second offender and you went to this DWI court and you got your drug sentence or your sentence reduced, why are you going to be able to go to the same court on the third offense, on the fourth offense, and keep getting your sentence reduced if you go to the same court? I think you should get one bite at the apple of going to the DWI court, and if after the second offense, you commit a third offense, you commit a fourth offense, why are we going to keep sending you to the same court and offering you the same reduced sentence? You know, so that's something that I would like us to reconsider as a body. And those are just some of the items that I was able to comb through. There's another area of concern that I had with respect to reducing the revocation of driving privileges. Like, for example, the original law is if you're a third offender conviction, your driving privileges are revoked for 5 years, but this new law would only make it for 2. And if you're getting convicted of DWI 3 times, I'm not comfortable reducing the revocation of your license down to 2 years. I mean, obviously there's a serious problem and you should not be on the road. So I'm not sure if I'm comfortable even voting on this bill at this time. I see the intent. I know that there's communication coming from the courts, and they're interested in, of course, updating the mandates and creating the the DWI court and allowing for there to be some kind of process that way. But just statutorily, I just have concerns with the definitions, with some of the ways the DWI court would be able to reduce sentences even for third or fourth time offenders, and even with the reduction in driver's license revocations. Those are just a number of items that I have, and I still have not, at least to my satisfaction, combed through the bill enough to really feel that the proposed mandate is crystallized. And so in that regard, I would like for the work to continue on this bill. I think, of course, that we should definitely consider implementing something like this, but perhaps it would require a little bit more committee work. And so I would like to make a motion at this time to refer the bill back to committee.
There's been a motion to refer back to committee. Vice Speaker?
I object to that motion, Mr. Speaker. I think the preceding speaker makes some good inquiries. I think those can be addressed. I think there is no reduction of penalty in this bill. The only reduction that is for this driver's license, and it's because of addiction, and that the court's experience in trying to compel behavior when there is an addiction involved. And this is a tool that they believe will be effective. And they want only for those people who are going to DWI court. And so they make their own, they have their own selection process as to whether you are a good candidate for this or not. And pretty much the good candidates are going to be those who are at high risk of repeating this offense. And because we want to keep these drivers off the road, we need to deal with their addiction. And I think the courts are finding not that, you know, it's a way to put them out on the street earlier, but it's a way to entice them to stay in treatment. And really it's just that enticement. And I think the court has absolute latitude here not to let a person have their you know, being restored to driving abilities if they don't feel that they are adequately complying with this treatment court. In fact, if they don't comply with the treatment, they are going to be denied all of those enticements, such as being able to drive earlier. But for those reasons, I object. I think there were several issues, and I think I could go through them one by one, but I would like to assure my colleagues that they are almost all dealt with as it's just, for example, the first one is one example. It was that whether it's under the influence of alcohol, sorry, let me just find this. Oh yes, page 31. While under the influence of alcohol, but these are actually controlled by the definitions that are put in this bill. For example, E, which defines controlled substances, and F, which defines driving while impaired, means any person driving a motor vehicle under the influence. And the attorney generals who are going to have to charge under this law, these are their high recommendations, is to use the definitions that are now in this bill, Mr. Speaker. And they don't believe that it's an impediment to charging these crimes.
I understand that it isn't an impediment, but I think the good senator's concern was, under the previous statute, when you said driving...
Mr. Speaker, yes, he says there's a definition that's crossed out on page
3 and 4.
3, right.
And driving under the influence goes on to add what you have in subsection 3.
Correct.
But
driving while impaired.
But the way that you have it under this current statute, is you separate them and you make them separate individual ones. So there could be one just driving under the influence of alcohol, and it doesn't necessarily need to meet the threshold of 0.08 or any amount. It's just, see, because when it
I
was
understand,
page
Mr.
3,
Speaker,
there
and
was,
I'm
there
saying
was
yes, that makes it,
10 lines after that explaining what driving under the influence was. In
Correct.
this one, you have one phrase, and it stops.
it's the same
Unless
thing
it-
with controlled substance, Mr. Speaker.
I understand, but
Yes.
is the intent to make it so that there is no need to meet a threshold and have a completely separate?
I think if you read all of the new definitions that they have put in, that it's going to have to meet the driving while impaired threshold. If you read it all together,
Well,
Mr. Speaker,
because you have controlled substance between those two,
I understand.
it looks like one by itself is sufficient. A by itself is sufficient. B by itself is sufficient. C by itself is a completely different charge, as opposed to, whereas previously it was driving under the influence if you met.
If I could just have a 1-minute recess, Mr. Speaker, I think these concerns are already addressed, but if you could just give me a 1-minute recess.
Take a recess. Senator Nicholas, you're recognized.
Thank you, Mr. Speaker. I understand that additional clarification is being sought, so at this moment I'll withdraw the motion to refer the bill back to committee, subject to your decision, Mr. Speaker.
All right. We'll pass this to allow you to have some time to consult and at this point, all right? So we'll pass it on file, and we'll move on to the rest of the second reading file. Senator Nicholas, you're recognized on your resolutions.
Thank you, Mr. Speaker. On Resolution 310-34, I'd like to make a motion to place this on the third reading file for consideration and be afforded an opportunity to speak on the resolution.
Any objection? Resolution 210.
310.
310. No objection.
Thank you, Mr. Speaker. Resolution 310-34 is relative to respectfully petitioning the United States Congress pursuant to 48 U.S.C. subsection 1423K to enact legislation amending the Organic Act of Guam to include a provision of Guam Public Law 26-74 for the government of Guam to deposit a required percentage of tax collections into the Guam Income Tax Refund Efficient Payment Trust Fund, and for the payment of income tax refunds, and that any such amendment be referenced as the Vicente C. Pangilinan Amendment. Just to provide some clarity, Mr. Speaker, 48 U.S.C. Section 1423K is a section within the Organic Act that empowers the people of Guam to be able to seek amendments to the Organic Act of Guam. And just for clarification, the Organic Act of Guam is the law of the land here on Guam. It is the equivalent of a constitution, with the exception that amendments to this document can only be done by the U.S. Congress and not directly by the people of Guam. However, with 48 U.S.C. Section 1423K, we can ask for certain amendments to be provisioned. And this resolution asks for a very specific amendment to the Organic Act. And this amendment is an amendment to basically make the late Speaker Ben Pangilinan, the law that he passed, Public Law 2674, to actually be in the Organic Act. And I want to explain briefly, Mr. Speaker, why that is important. Public Law 26-74 mandates that a percentage of all income tax revenue that comes into the government gets deposited into a specific trust fund, so that trust fund can then be used to pay tax refunds to our people. Now, the way it's supposed to work is withholding taxes that are collected by the government are supposed to be withheld in trust from the paychecks of our people to pay their tax refunds. Unfortunately, the way this government budgets, we do not do it that way. The withholding taxes are taken in and they're used to run the operations of the government. So where's the money supposed to come from to pay for tax refunds? That, Mr. Speaker, has been our perennial challenge for decades. So the late Speaker Ben Pangilinan tried to fix that problem by passing a local law to take a percentage of all income tax money coming into the government, put it into this fund so that we can have the money to pay out our tax refunds. There's just one problem: the separation of powers. The control of cash coming into the government is strictly an executive branch function. Only the administration can decide where a dollar is supposed to go with respect to the appropriations of this government. Now, recently, the late Speaker Pangilinan and this legislature successfully took the administration to court because they were taking money out of the fund that he created and using it for government operations. The separation of powers does not apply to the establishment of a fund and the mandates associated with it. So the administration taking money out of a fund was in fact a violation, and the courts upheld that. But what the late Speaker Pangilinan never did was he never took the administration to court to force them to make the deposits. He never took them to court to force them to deposit. And the reason why is because in his wisdom he knew that the separation of powers would result in a court ruling where the courts would say the legislature cannot compel the administration to deposit. So as long as this is a local law, it becomes a separation of powers issue where the local law will never be able to compel the executive branch to do something that is expressly within its powers. There is only one law that can compel any branch of government to do anything, regardless of whether or not it impinges upon the powers of any other branch. And that law is the law of the land. It is the Organic Act. If we put the late Speaker Ben Pangalinan's local law into the Organic Act, the administration will be compelled to follow it. And when I say the administration, I don't mean just this one. I mean every single administration, including this one and everyone thereafter. We recently talked about plastic bags and solving a 500-year-old problem. Putting things into the Organic Act and making it the law of the land until such time that we have a constitution, a political status determination, until such time that we have any of those things, putting these things into the Organic Act will solve the problem in perpetuity until such time that there is a new law of the land to replace it. Now, why would we want to do this? As I mentioned earlier, Mr. Speaker, this is a perennial problem. Tax refunds have been used, the money that's supposed to pay tax refunds, that's supposed to go into this account, has been used to kite the operations of this government instead. It's like taking out a perpetual funding stream that's supposed to go to our people and instead using it for everything else that this administration or any other administration wants to use it for. And so what happens is when we don't put the money away for tax refunds, we create a liability because eventually those tax refunds need to be paid. And historically, the payment of tax refunds could take years upon years upon years. And it wasn't until a recent court case, the courts coming down saying you have to pay within 6 months. But between now and then, Mr. Speaker, the inability to make these deposits has devastated the finances of this government. It has impacted our public debt so horrendously. And it is articulated in the resolution, which I would like to put on the record. Sorry, on page 2, line 3. Whereas the government of Guam was unable to set aside money to pay for income tax refunds for nearly 2 decades and has relied on accumulated deficits and subsequent borrowing on the bond market to pay accrued income tax refund payments owed to taxpayers. And whereas in August 1994, 24 years ago, the government of Guam borrowed $45 million in the bond market, all of which were used to pay for 1993 tax refunds under the General Obligation Bonds 1994 Series A, as authorized by Public Law 22-138. In June 1995, 1 year later, the government of Guam again borrowed $115 million on the bond market, of which $41 million was used to pay off the 94 tax refunds under the GO bonds, as authorized by Public Law 22-138. In June 2009, 14 years later, again, the government of Guam borrowed $271,070,000 on the bond market, of which $112 million were used to pay for delinquent tax refunds for prior years under the General Obligation 2009 bonds, as authorized by Public Law 30-24. In December of 2011, 2 years later, the government of Guam borrowed $235 million in the bond market, of which $198 million was used to pay for 2010 tax refunds in prior years under the Business Privilege Tax Bond Series 2011A, as authorized by Public Law 30-24. In June 2012, 1 year after that, the government of Guam borrowed $108,700,000 on the bond market, of which $60 million was used to pay for 2010 and 2011 tax refunds under the Business Privilege Tax Bond Series 2012B, as authorized by Public Law 30-24. In April 2011, a class action lawsuit was filed on behalf of Guam residents Jeffrey and Rhea Paesti and Sharon and Glenn Zapanta, challenging the government of Guam's failure to pay tax refunds to its taxpayers in a timely manner. In January 2013, District Court Judge Consuelo Marshall, District Court Judge, Federal District Court Judge, issued a permanent injunction in the case of Paesti versus Gov Guam, ordering that the government of Guam must pay tax refunds no later than 6 months after tax returns are due. On December 2011, the Guam Office of Public Accountability released a report of performance audit of the Income Tax Refund Efficient Payment Trust Fund and concluded that the government of Guam failed to pay $41 million into this trust fund in 2011, citing the government of Guam Department of Administration and failing to adhere to the requirements of Public Law 2674 when it did not always make these deposits. Mr. Speaker, Democrat, Republican, administration A, B, C, it doesn't matter. This is a problem that plagues our community and buries us in debt. And even after the court ruling in January 2013, we are still being put a tran to still try and borrow, because even 6 months is too long for us to somehow get our act together and make the deposits that we're supposed to. And what happens down the road? A tran to pay a tran? Mr. Speaker, we owe it to our people to fix the problem. And the way that we can do it is by making this an Organic Act amendment. And so I humbly ask my colleagues to join me in this season right now where we have so many people waiting for tax refunds again and a failure to deposit again. Let us solve this problem not just now, but for however long the Organic Act remains the law of this land, so that we will no longer have this problem of trying to figure out how to pay tax refunds and ultimately burying our people under more and more debt because we can't follow our own local laws. The Organic Act of Guam is the one law that everybody must follow. I humbly ask my colleagues to help us finally resolve this problem and seek this Organic Act amendment by passing this resolution. Thank you, Mr. Speaker.
Thank you, Senator. On the main motion, any senator wish to be heard? On the main motion, any senator wish to be heard? If not, Vice Speaker.
Thank you, Mr. Speaker. Mr. Speaker, there are things that we should go to the United States Congress for. We should go to the United States Congress for war claims because it is they who can provide justice for the atrocities of war and who waived the people of Guam's claim against Japan. We should go to Congress for justice for the people of Guam who were exposed to Agent Orange and nuclear fallout. We should go to Congress in the United States for equity in Social Security and equity for our veterans. We should go to Congress to stop the United States Department of Defense live fire training and testing in our waters and lands, and to stop the United States military from bulldozing acres of pristine limestone forests. And we must deal with Congress when it comes to self-determination, because the United States is the current administering power of Guam under international law. These are very valid reasons to go to the United States Congress, but to impose further restrictions on the government of Guam, no. For further restrictions on ourselves, we should not go to the United States Congress. Additionally, in regards to the resolution number 310, I think the timeline and the whereas clauses in the resolution point out some great work. It leaves out some important facts, however. First, governors used the cash that should have gone to tax refunds on operations. Senator Ben passed several good laws mandating the set-aside of tax refunds before cash was spent, direct deposits from monthly receipts from taxpayers. And when the governors worked around these laws, Senator Ben went back and amended those laws over and over in creative ways that would hold the governors more accountable and that would aid in taxpayers seeing exactly what was going on. In addition, to deposit and lockbox mandates. For the first time ever, Senator Ben included a provision for tax refunds in the budget bill, establishing a practice that we continue today of prioritizing and itemizing refunds in the annual budget bill and appropriating less revenues than are expected in order to set aside for prompt payment of tax refunds. When governors continued to ignore these laws, Senator Ben and his colleagues did what we want legislatures to do. By way of declaratory judgment, Senator Ben was successful in getting the Supreme Court of Guam to order that taxes in the tax trust fund cannot be spent elsewhere. Somewhere along this timeline, the borrowing for tax refunds that Senator Ben tried to prevent was approved by a legislature or two. Somewhere along this timeline, members in this body still alive today were elected. With the hard work and seeming repeated and frustrating attempts, there has been some success. I, for one, am here to add to those successes and to withhold legislative concurrence on the impediments to prompt payment of tax refunds or the need for continued borrowing. At the public hearing, there was only one person who testified, and he was not in support of this resolution. I think most of the testimony on all three of these resolutions was against the resolutions, and there were no letters of support included in the committee report on this resolution. I never imagined it would actually make it to session. It is ironic, if not misguided, that senators who served not just months, but years with Speaker Ben Pangilinan would think for 1 minute that this would be an honor to him. Perhaps they didn't hear his words. I'd like to read some of those words into the record on debate on this resolution, which would use his name quite frankly in vain. Senator Ben said, "Today, in a time full of cynicism, political sound bites, and press releases, we must remember who we are as a people. We once mastered the navigation of the seas. Surely we can determine our political future. We survived a world at war. Surely we can build an economy which leaves no hardworking families behind. We are the inheritors of an ancient land. Surely we can leave this place better than we found it." I believe this resolution sends the wrong message not only to Congress about what the people of Guam are capable of, but also to the supporters, friends, and family of Senator Ben and his legacy. He was a staunch advocate for the payment of tax refunds and of the system of checks and balances, fiscal responsibility, accountability, and transparency. We do not need more federal restrictions, we need less. This is not a time to give up and hand governance over to the colonizer because we can't get our way. It is a time for all of us to work together even harder. We need to lead when we can and to follow our people every step of the way. Thank you, Mr. Speaker.
Thank you, Senator. Any other senator wish to be heard? Senator Estevez.
Thank you, Mr. Speaker. In reviewing this resolution, I stand in opposition. While I understand the intent of the resolution to attempt to get tax refunds paid out sooner, it fails to consider the things that actually go on. Mr. Speaker, I refuse to believe the implication that for decades, governors and administrations, both Democrat and Republican, spanning 4 different administrations, just didn't want to comply, just didn't want to pay out tax refunds. We have perennial problems, and it's not that we don't prioritize tax refunds, Mr. Speaker, because even in this body, we budget accordingly. The perennial problem has been our link to the U.S. tax system. To date, approximately $78 million in EITC, that is paid out of pocket. Let me say that again, it's paid out of pocket. That's money paid to tax refunds that doesn't come from any source except the people that make enough to pay income taxes. It's always going to be a matter of catching up. When you have those that have a refund due to them for their overpayment in taxes, and that money that should be going to government operations is subsequently also paying for the credits to those that don't make enough to pay into income tax, then you're always going to have this issue. This constant comparison, comparing us to states in which their earned income tax credit is paid for by the federal government in that juggling act, is not accurate, Mr. Speaker. We need to address what the real problems are and focus on trying to fix those. But I do believe that the administrations on both sides of the aisle, both Democrat and Republican, both new and old, have made attempts as much as they could while maintaining and operating this government in trying to pay out tax refunds. And we've gotten better. This is a problem we can solve ourselves, Mr. Speaker. We haven't even begun to see what the ramifications are. If this were to get ratified, and we would prioritize, this is a backdoor attempt at slashing the government of Guam overnight. Because if this does come into play, if this does become a reality, then we'll have a lot of money sitting into account to pay tax refunds, and you'll see the government of Guam split in half overnight. You'll see jobs lost, not by our own making, but a premature pro-Mesa. So I do stand in opposition of this resolution, Mr. Speaker. I believe these are issues we can solve. I believe if we wanted the ability to pay tax refunds, if we truly believe that it's just a matter of this administration and previous administrations who are absolutely inept and just don't want to pay tax refunds, then maybe we need more people running for the gubernatorial office who can fix it themselves. But with us within this body, we need to keep working with our counterparts in the other branches of government. We can't circumvent the democratic system of checks and balances, Mr. Speaker. Yes, it may be difficult. Yes, the road ahead of us may be difficult. But that doesn't mean we just go run to the principal's office because it's a little hard. It means we work harder. It means we build compromises. It means we build working relationships. It means we identify the real problems instead of pointing fingers at people who are not even present to defend themselves. Thank you, Mr. Speaker.
Thank you, Senator. Any other senator wish to be heard? Any other senator wish to be heard? If not, Senator Nicholas, you're welcome to close. Oh, wait, I'm sorry. Senator Espaldon.
Thank you, Mr. Speaker. Mr. Speaker, this resolution seeks to have our Constitution amended, our Constitution being the Organic Act at the present moment. It seeks to put into our Organic Act, our Constitution, the directive that a certain percentage of income tax coming in, of tax revenues coming into the government be set aside for the payment of income tax refunds so that it can be paid in full come tax time. It seems to me like a very logical way to do things in terms of if it's within our Constitution and that's the mandate upon our government, then let it be. And it reflects the law that was passed in years past. I can appreciate that because going forward, how do we ever get to that point where we can fully cover tax refunds without having to borrow? I think that's the whole genesis of this resolution. As much as I appreciate the effort, and I still may vote for it, I think one of the problems I do struggle with is perhaps just some of the comments that previous speakers have just made. They definitely have some merit. The issue of the EITC came up. I think that has merit because as we see more of an influx into our island from other Pacific Island nations, right, we have also seen an increase in the EITC, Earned Income Tax Credit. And our colleague was correct. In other jurisdictions throughout the United States, the federal government reimburses the state governments for the payment of EITC. On Guam, the federal government does not reimburse us. So even predicting what would be owed to EITC recipients, right, is quite difficult. But that doesn't mean that we shouldn't set aside money as the revenues come in. But then the issue becomes something that I think that we have heard several times when we've had committee of the whole or somebody coming in from the administration saying that this is a very hard task to do because we've always been playing catch up. And unless there is perhaps a little money put in initially to help the whole process, then the government's hands will be hampered, or the government's ability to pay vendors, to pay its obligations, whether it's payroll, whether it's for operations, will never be funded as it is dictated, or at least conceived in this legislature setting a budget for the government. Because, again, there are a lot of unknowns. I think the argument that should we go to the federal government to say we can't control our own selves, so now we're going to ask you to put it in the Organic Act, which you created for us, right, to make sure, put in a provision to make sure that we can control ourselves. And I think that's what our colleague, one of our colleagues was speaking to, is that really, is that the message we want to send to Congress, that because we can't control our own selves and because we cannot behave or run our government according to perhaps best practices, that we need you to now come in and tell or put into the Organic Act, our Constitution, that this is what needs to be done. I'm a little conflicted, only because I believe that something needs to be done in terms of setting aside some money. There was a law that was passed in earlier legislature, right? But it really hasn't been adhered to. And the reason why they say the administrations, not just this administrations, have said that they cannot adhere to it, of putting some money aside for tax refunds, is because of the continuous payments that are required of Guam. One of the things that we're seeing, that we do know that exists, is that even in terms of the operation, the cost of operations of this government, right, the whole issue of incremental pay, right, increases the budget requirements of Guam every X amount of years. And so that's in law. That's how this works, right? We can't just say, okay, we're going to set the budget at this cap. Say, for example, at last year's income or last year's expenditures, because we know that this year's expenditures or next year's expenditures will probably be higher because of other requirements in law. For now, then, the Congress, for us to seek guidance from the Congress, or not even guidance, for us to seek Congress to actually dictate now to us and tell us, we're telling them to tell us, here's what you're going to have to do. I guess I have a little problem with that, Not that I'm against the principle of setting aside money for tax refunds, but there is this, I guess, undercurrent even within our community, I believe, right, that we need to establish within ourselves and redefine ourselves and prove to ourselves that we are capable of running this government, of running our island the way it should be run, instead of running to some bigger power and saying, tell us what we need to do or mandate us to do this, as opposed to us taking the initiative just to do it. And I think this is where really, when you start talking about elections of leaders, especially those for the executive branch, it's very important that we all understand who gets to sit in that chair. And it shouldn't be just a popularity contest. It should be based upon arguments and premises that these candidates put forth that will establish a trust that they will run this government fiscally responsible, right, so that this island can continue to grow, pay its bills, and prosper. I guess the problem I have is to have the federal government tell us, you need to do what you say you're going to do. I think it's within us to be able to say, this is what we really need to do, right? And this is what we're going to hold the executive branch to doing. We're going to hold the legislative branch to make sure that we also are held responsible to making sure that we don't over-appropriate and just take the administration's word that only X amount needs to be set aside, because we're finding, I believe, that even though we've been talking about $100 to $120 million for tax refunds every year, that really we're paying out much more than this. But this is the responsibility of this government. It's the responsibility of the executive branch, our chief executive officer, our governor. It's the responsibility of the senators within this body to always recognize that there is going to be tax refunds that need to be paid out, and it may be even in excess of what is being appropriated. Like I said, over the past few years, it's been 100 to 125 million. In fact, I think 125 million is that magic number that we constantly use, regardless of whatever, it is. So it's our responsibility. I don't know how I will vote on this yet. I really don't. I like the concept in that there's got to be something firm that the executive branch and even this legislative branch cannot obviate, cannot go around. It would be the law of this island if it is put into the Organic Act that you must. However, like I said, from past testimony from administration officials, the fiscal realities may not always allow us to put aside X amount of money every month, every time income comes in, because there are definitely peaks and valleys to the income into this government, but yet there is a steady stream of costs that need to be paid. And so when we dip into the valleys of income, of tax revenues coming into the island, when there's a dip, how do we make up for that? Because we still have to pay the vendors, we still need to pay our employees, we still need to pay operation costs, and yet during that month, it is the revenues have dipped. And so any money that should be set aside can't be set aside because those payments need to be made. And if it is put into our Organic Act, then we could definitely foresee some very uncertain and uncomfortable situations. I'm still open to hear other members of this body speak to it, and I'm hoping they can perhaps sway me one way or the other. But I do understand some of the realities, but I also understand the objective of this resolution, and that is to make sure that we do not burden our people with borrowing on the bond market for monies that we should have been setting aside from the beginning. Again, I just wanted to express some of those thoughts, and perhaps I'm looking forward to more dialogue on this issue from our colleagues. Thank you, Madam Speaker.
Thank you, Senator Espadon. On the bill, on the resolution, Speaker Cruz, you are recognized.
Madam Speaker, thank you very much. I was hoping to hide behind the chair and not comment, but I am torn with the retiring speaker saying that he's having problems trying to figure out which way he's going to vote. I felt compelled that I had to come down and at least try to explain to my colleagues and to the public the dilemma that I find myself in. The dilemma that I find myself in is that as the Appropriations Chair, I understand the need for this, and I understand the need for wanting to do this. As a nationalist, I also understand the other side of the argument that we shouldn't be running to the federal government for assistance, and it should be done by the bodies, that the legislature should be able to do this, or the governor should be able to do that. Set that aside, having made that decision. The dilemma that I find myself in is that I'm trying to figure, I don't want to be accused by others who know my history of being hypocritical about the position that I take. Because there was a time almost 20 years ago when I did the very exact same thing. $20 ago, in a few months, I was elected Chief Justice of the Supreme Court. But I was elected Chief Justice of a Supreme Court that was not supreme. $20 ago, I and my colleagues on the Supreme Court were standing at a window in our robes, at the committee room window, hoping that the legislature would recognize the supremacy of the court and not gut the reorganization of the court bill that had been passed previously, and to separate the operations of the Superior and the Supreme Court. I convinced my colleagues to come with me to stand at that window in our robes in the hopes that the legislature would do the right thing. Unfortunately, the legislature did not do the right thing, at least in my estimation. The legislature gutted the Supreme Court, split the jurisdiction, split the administrative. So I became Chief Justice of 20 people, as opposed to a 300-person branch. I became Chief Justice of a court that was no longer invited to this body to deliver the judicial address. Of the state of the judiciary. So I resigned my seat early upon reaching the effective date of that I could be eligible to retire. And went to Washington, D.C., and worked with then Congressman Underwood to get the Organic Act amended to return the Supreme Court to its supremacy. So I have gone to the principal, as it were, because I didn't believe that the right thing had been done. And so I'm torn. I understand the separation of powers, and I understand the importance of reading the Organic Act in its minutia as the way that things are going to operate. And unfortunately, we saw the effect of that earlier this year with the, or can't remember when the decision was issued, when the Supreme Court, when the Supreme Court ruled in the Tran case initially. And reading the Organic Act in a way that I was hoping it wouldn't, really did trample on our separation. And our power to be able to have our own rules and make issue that opinion that said that a majority of those present and voting could pass the law, which if taken to its absurdity would mean something could pass this body by 3 if we were to take a vote today, right now, on something. 5 of us could recuse ourselves and 3 could vote and 2 would pass, because it'd be the number of the majority of those voting, which would be 3. There was a quorum. So I understand the importance of the Organic Act. But I have also utilized Congress and the Organic Act to reinstate a branch of government 20 years ago when we were gutted, and so I understand the need to try to reinsert ourselves or have the executive understand that when we set aside $125 million for the payment of tax refund, we expect that $125 million is going to be set aside and put into an account so that when and if it's needed, it may not be needed in January, it may not be needed in September, but as it's needed when the filings come in April and May, that the refunds are paid in a timely fashion. So though I may on one side not want to run to the principal's office because I was bullied I have to admit publicly that I have in the past run to the principal's office and may, for consistency, have to vote in this for this resolution because of the fact that I would like to reestablish this body in a decision that we made. But so I just wanted to make that confession publicly, and so that it would be understood when my vote is cast in this resolution. I'm not asking for anybody else to follow me in it, but it's just because of that I have in the past utilized it. I may have to, by consistency, to be consistent, utilize this temporary measure. Thank you, Madam Speaker.
On the resolution, is there anyone else who would like to speak on the resolution? If not, the author may close.
Thank you, Madam Speaker. The introduction of resolutions like these do not make political sense from the rawest view of somebody running for public office. The politically sensible thing to do is just constantly let things continue the way they are, keep symbolically trying to show that you're fixing it, throwing your hands in the air when it doesn't get fixed, and then trying to perhaps ride into the rescue somehow as a savior with a bond, with some kind of special appropriation. But Madam Speaker, that does not solve our island's problems. That does not make this community stronger. It provides for political longevity. It does not build a responsible Guam. This resolution, Madam Speaker, is not an abdication of our ability to self-govern. It is an acknowledgement that we know what has to be done and we're going to do whatever it takes to make sure it happens. And it's not some trivial matter. It has to do with the tax refunds getting to our people by the same funding mechanism that we ourselves passed into our own local laws. The notion that we're somehow running to a colonizer to solve our problems makes no sense to me when this is our very own solution. And the holdup is just the fact that it's unenforceable due to the separation of powers. And the only way we can get it enforceable is by making it supersede that hurdle. And the only way we can do that is by putting this into the Organic Act. I'm not quite sure about other members of this body, but I'm a history major. I got my degree at the University of Guam. So my history degree is not tainted by some colonial education. I am a UOG graduate with a University of Guam history degree. And I cannot imagine at what point did the Organic Act of Guam all of a sudden become a representation of our subjugation. Madam Speaker, the Organic Act is the single greatest representation of our ability to achieve on our road to self-determination. The Organic Act wasn't something that was imposed on the people of Guam. It was something that was achieved by the people of Guam. Our neglect of that history and our attempts to revise it into something negative astounds me. Prior to the Organic Act of 1950, this island was ruled by a naval administration that did not really care what the local assembly wanted. My grandfather on the San Nicolas side, Enrique Santos San Nicolas, was a member of the Guam Congress that walked out when the naval administration would just arbitrarily ignore the intent of the people of Guam. Subsequent to that walkout, our people fought and achieved what is currently our Organic Act. Is it perfect? No. Is it the end? I sure hope not. But it is certainly not something that a colonizer imposed upon us. It is an achievement of our people. And so when I invoke the Organic Act to solve this problem perennially for our people, I'm not running to no colonizer. I'm invoking our forefathers who got us to this point. And Madam Speaker, the sad reality is it's the farthest that we've come. The journey to self-determination has not taken a single step forward when it comes to self-governance beyond the Organic Act. We reject a constitution. We are unable to come to terms with what it takes to have a law of the land here, and so it is the only achievement that we have. And now we have somehow spun that achievement into a representation of our subjugation when it is in fact a breakthrough and a symbol of what we can achieve. The problem that we have today, Madam Speaker, in moving our island forward in any kind of self-determination or in any form of self-governance is the very examples that I listed in this resolution. And while the notion is we should be able to do this ourselves, the reality is we have not. These laws are on our books, and the only reason why tax refunds get paid in 6 months is because of a federal district court that has imposed that. This resolution is not an example of us unable to do what we must. It is an example of us willing to do whatever it takes, using the very tools our forefathers gave us to resolve these historic problems in our finances that are actually holding us back so much that our people are leaving island, our roads are staying broken, our ability to believe in ourselves and our ability to manage our own resources is compromised. And that is why an Organic Act amendment will actually be a step forward, because it will compel, no matter what the administration is, it will compel it to make those deposits. These kind of positions are not easy because there are those in the community who would instead view actions like these as something to not only criticize, but to slander. But I'm even willing to stand alone, Madam Speaker, if I must, because I know this would solve the problem. And I am not ashamed to do it any more than our forefathers who were in these halls. We're not ashamed to walk out of these halls to get an Organic Act for us. And I invoke these same forefathers in this same hall to inspire the hearts and minds of the members of this body and our people to not be afraid of our own shadow, to not be afraid of our own achievements, and to use them to strengthen our community so that one day, from a position of strength, we can take the next step, the second step, after the first that was taken in 1950. You know, Madam Speaker, there were certain references to federal mandates that are somehow drowning us. And there are definitely federal issues that we need to address, and I really want to go out there and address them. But we also need to contextualize why they are problematic. One of them that was referenced was EITC. And yes, this is an unfunded federal mandate. But let us remember that it was the local government that chose to pay it out. We did it to ourselves. And after paying it out, then the court said, if you're going to pay it, then you must continue to pay it. For everybody. Fairness. So as we work to reconcile these challenges that we have, let us also take the opportunities that are present and fix the problems that are plaguing us, rather than collectively trying to create an excuse for why we are not doing what we're supposed to. And in so fixing it, let this be finally our acknowledgement to ourselves and to the federal government that we do know what the problem is, and we are willing to bring it forward and remedy it. Rather than use it as some kind of banner that champions a cause that has just really left our people disappointed. This is our opportunity to continue the work of our forefathers, to properly contextualize the achievement that is the Organic Act, and to move our island forward to resolve the problem of tax refunds not getting deposited so that our people can get their money. Basic and honorable. Thank you, Madam.
On the motion to send the resolution to third reading, are there any objections? I object. So on the motion, please raise your hands.
Madam Speaker, just to be clear, we are voting right now on setting it down to third reading?
That's correct.
Thank you.
Call of the House,
All in
Madam
favor,
Speaker.
please raise your hand.
Call of the House. There's only 8 members. Your objection would prevent it from going down to the third reading file. You are single-handedly stopping this resolution from moving forward, Madam Speaker.
I wish you called for a call of the House at the beginning of this. Mr. Speaker, would you like to preside?
Senator Torres, did I see your hand go up for?
Mr. Speaker, at the risk of speaking out of turn or out of order, I respectfully request that the objector to the motion reconsider that objection. I just want to point out to the body, Mr. Speaker, that this resolution was voted out of the Committee on Rules to be put on the agenda. It has been heard on the floor, presented. There was discussion by members of this body on the resolution, and without any valid objection to it in substance, I don't see that there is a reason why it is not worthy of a vote by the body. And
Mr.
so
Speaker,
to that,
I
I
believe
just
that's
respectfully,
totally out of order, Mr.
request.
Speaker.
It is at the risk of sounding out of order. I
We're
think
on
that
a vote, and either we vote or we go back to second reading and we discuss the bill further. I have no objection to that, but if we're on a vote, point of order, Mr. Speaker.
I just don't see procedurally any basis for an objection, and that's what I'm calling out. If there was no substantive flaw that was pointed out about the resolution, I just calling the question at the risk, just for the body. I believe that everything has its due course.
I understand.
Mr. Speaker, if we're going to debate this motion, then I would like to be afforded that opportunity also.
Unfortunately, I have to call the vote on the motion.
Mr. Speaker, I believe that there was a motion for call of the House, and I believe that is a motion of personal privilege that should supersede all other motions. And if please correct me if I'm wrong.
But that is just a motion. And so there has to be a vote on the motion since there was an objection.
Now, if there was a motion or point of personal privilege, I believe that should supersede even the vote and the vote on the motion, correct?
And is there a motion on personal privilege?
I believe the good senator did request or did make a point to, for a call of the House, and I believe a call of the House is a point of personal privilege, or a motion under a point of personal privilege.
I've been advised by the Parliamentarian Legal Counsel that it's a motion for which I have to call a vote. As a motion.
Just for clarification.
Then, Mr. Speaker, I will depart, and there will be no quorum to continue.
We've lost quorum. We'll take a recess till 2 o'clock.